York City, why can you charge a person with criminal possession of a weapon if they, I'm sorry, why can you charge a person with criminal possession of a weapon if they have a loaded rifle in the street? It's only an administrative code in New York. Why is this only for handguns? I think you meant to say, why can't you charge a person?
I think the answer is why can't you?
Okay.
Or that's the question. New York penal law, the New York State penal law, which obviously controls throughout New York State, defines a handgun as being a firearm.
Yeah.
Firearm is defined as a pistol, a revolver, only short guns. Quite frankly, you go outside of New York City, you can go to the Walmart and you can buy yourself with a New York State driver's license. You don't need a license. You can go buy a shotgun or a rifle.
Yeah.
Now, New York City has a slightly different rule, and it's in the administrative code of the city of New York. It is a crime. It's a misdemeanor to possess a rifle or shotgun in public without a license.
Okay.
But it's only administrative code violation. It's only a misdemeanor, and it's because I believe of the legislative belief that rifles and shotguns do not pose as much of a danger to citizens, because no criminal is going to walk around with a shotgun or a rifle. Now, if someone cuts down the barrel to below a certain length, sawed-off shotgun, below 18 inches for a shotgun, below 16 inches for a rifle, that's a different story, and that makes it a pistol.
Yeah.
Oh, really?
Yes.
So wait, what were the measurements?
Whoa, that sounds
again?
scary.
What were the
That's the
measurements?
cops coming up the stairs for you, too.
So wait, they said if the shotgun, if you cut it down to below how much?
18 inches
Yeah.
for a shotgun, and 16 inches for a rifle.
Then it's a felony.
Hang on, yeah, not only is that a felony, but that's a heavier charge because there's some type of intent, yes?
Well, the way the law is written now, that they've just modified this law, this would be classified as possessing a loaded firearm outside of the home or place of business, and would carry a mandatory minimum of 3.5 years as a minimum, and up to 15 years in prison.
Let me also say that you guys, Tilem and Campbell, pardon me, attorneys at law, you guys specialize in real estate, child abuse, neglect, landlord-tenant law, yes?
Yes.
Personal injury, wills, trust, and estate administration. Let's go to child abuse, neglect for a minute here, because sometimes we have disgruntled neighbors, we have so-called friends who will make a call and report a person who is a tax-paying, law-abiding person who may get caught up in something that they did not intend to do, which is neglect a child, and then their life gets turned upside down.
That's correct, and I handle a lot of these cases for our firm, and you're absolutely right. In New York State, an anonymous phone call to the child abuse hotline can set off a major investigation.
Yeah.
Under the regulations, there's supposed to be a face-to-face interview with the child and the family within 24 hours. Many people don't know that they can decline that interview. And it does take just an anonymous phone call or a disgruntled neighbor, someone with an argument.
Yeah.
There are some
Someone
states...
with a gripe who you may have dated, and
Exactly.
this person knows the intricate details of your comings and goings, and they just want to make your life hell.
It happens a lot in custody battles between parents. And, there are some states that will not follow up on an anonymous phone call. And there are also some states that will have a way of parsing out what they consider more urgent calls than others. It's called a dual track system. New York State has been contemplating implementing this so-called dual track system so that phone calls that make allegations that might not really be something that are going to pan out or are not that serious don't result in this very intrusive investigative process. I don't think many people realize the powers that the social workers that show up at your door have to take your children.
Oh, yeah.
And the limited rights that you have within the family court system that would adjudicate your case. You have no right to a jury trial in that type of situation. And if you don't know that you don't have to let them in, and if you don't know that you can call an attorney right away, you might say something or allow an investigation to proceed and wind up.
Can we give out your 914 number also?
Sure.
Okay, for all another number to contact law offices of Tilem and Campbell is 914, folks, 833-9785. That's 914-833-9785. Criminal defense, personal injury, child abuse, neglect, estate planning, real estate, landlord-tenant law, Article 78 proceedings, commercial real estate litigation, business law, prenuptial agreements as well. You guys get involved with the, I would imagine so, the subpoenas, discovery, depositions, stuff like that?
Yeah, absolutely. The discovery, well, there's discovery in criminal cases as well as civil cases.
Right.
And depositions are in New York State only in the civil arena.
Before we get into some phone calls, just my limited knowledge, let's try and point out to people who may get dragged into or become a party in a criminal. If I'm saying anything wrong here, please correct me.
Sure.
Criminal proceedings. Discovery is the request for documentation.
Well, there's some discovery that you request, and there's some that's mandatory that has to be turned over.
Yeah. Now, if I can finish here, text messages, emails. Got to be careful out here, folks. I myself don't have a BlackBerry, and really fighting to have one because I don't want to be pulled into someone else's possible investigation by way of the RICO statute, guilty by association. But there are people who do get pulled into this. So, what can you, aside from having people call you guys, is there any type of, and I don't want to say free advice, anything you might want to say about people who are pretty reckless with these text messages and stuff like that?
You know, look, I think the message is be careful because if you send a text message, you send an email, and the way I see it come up a lot is you send an email, you think you're sending an email to your friend, and you hit reply to all. And you've sent it to who knows how many people.
I mean, even if you don't hit reply to all, there are new Patriot Act laws that allow the observation of certain emails based upon how you title the email, yes?
Absolutely true.
Yeah.
And quite frankly, you have to remember that when you send an email, it is possible, whether you're involved in the dispute or two other people involved in the dispute, that email may show up in a courtroom someday. And how are you going to feel testifying about that particular email? So you have to be careful.
Well, remember that the news anchor in Philadelphia, who just was all over the news because he was tapping into his coworkers' emails and all that stuff. Yeah, because he was jealous because she was getting paid more money, but apparently they had some sort of personal thing. Yeah, I just wanted to bring that up.
Yeah. Thank you very much. Good morning. Is this Cookie Man from New Jersey?
Your question: were you arrested driving, or were you? Did a warrant come up for not appearing on the original registration ticket? Okay. Well, because the original registration ticket could have been a misdemeanor depending upon how they charged it. And if you failed to appear or answer that, whether your company thought was going to do it or you were going to do it, that could have resulted in a warrant. Also, by failing to appear on that registration ticket, your license was subsequently suspended. So when you were pulled over and they ran your license, then you were charged with aggravated unlicensed operator, which is an unclassified misdemeanor. In your particular case, you would have been facing up to 30 days in jail. There is no obligation, while many employers will, as a matter of course, take care of the tickets for the vehicles. It's your obligation when you get in a vehicle to ensure that it's insured and properly registered. Now, I know many of us don't do that. You borrow a friend's car, you're driving an employer's truck. Many employers do handle these tickets, but ultimately, if the ticket's in your name, it's your responsibility to make sure it's taken care of.
We probably handle over 300 traffic tickets a year and handle everything from speeding to driving with a suspended license. These are serious matters. Your license is in jeopardy. There are some of these little upstate judges that have thrown people in jail for speeding. So consult a lawyer. Don't just walk into court, plead guilty, because it has a lot of consequences. Well, obviously the facts of your particular case, so I'm going to talk in generalities. If you have a subpoena, you are obligated by law to appear in court and answer questions. But generally, you do not have to participate in an investigation. So it doesn't matter whether it's an investigation by the prosecution or an investigation by the defense. Unless you have some court mandate, then as a general principle, you do not have to cooperate. Well, I mean a subpoena. I mean some kind of court order directing you to appear, and that's what a subpoena is.